For now, you are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
For the record, my name is Thomas Styron II. It is not the name you have attached to this case. I believe that's a state created entity, Your Honor. Okay. And me being a living person. My name is in proper punctuation. I don't have a all caps name. So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
14B District Court is now in session. This is Magistrate Hillary Braley presiding. Okay, and I need you unmuted at the jail. There we go. Can I have your name, please?
For the record, my name is Thomas Styron II. I'm the natural person, I'm the living man. How we doing today, Miss Braley?
We are upright, if nothing else. Great. So, okay. And you said your name is Thomas Styron.
The second.
The second.
And then I'm the natural person.
So, no, recalling case number 19S00472. That is the state of Michigan versus Thomas Ulrich Styron, the second, you said. And also calling 24W001025. That is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. It is not the name you have attached to this case is not.
Right from the start, you can feel where this is headed. We're watching a familiar sovereign citizen playbook unfold in real time. Identity challenges, jurisdiction arguments, and technical language meant to derail a simple legal process. Instead of focusing on the actual charge, the defendant immediately pivots to theories about names and entities. This opening sets the tone for everything that follows. The court is here to handle business, while he's here to debate philosophy. And that clash. That's exactly what turns routine hearings into extended courtroom standoffs.
I believe that's a state created entity, Your Honor. Okay. And me being a living person, my name is in proper punctuation. I don't have a all caps name nor.
Okay, I'm going to cut you off right there.
I don't have no contracts with the state of Michigan at all, period. And so I was wondering about personal jurisdiction and subject matter jurisdiction in regards to this.
Okay. And you can continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at.
Here's where things start to drift off course. Rather than confirming basic information, the defendant leans into sovereign ideology, separating himself from the name on the case and reframing his identity as a living man. This tactic shows up constantly in these hearings, but courts don't operate on personal definitions, they rely on records and legal identity. Notice how calmly the magistrate proceeds despite the resistance. This moment highlights the gap between internet legal myths and real courtroom procedure, and that gap only widens as the hearing continues.
Or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not. I don't even own a license. I canceled my license years ago.
Okay. So, what you are being charged with is operating a motor vehicle without having a license on your person. So, I'm not asking if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused me of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I was traveling home.
Okay.
I wasn't doing business at all. And also from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir. But we are not going to get into that for now. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail.
This is the pivot point where the court draws a clear boundary. The magistrate redirects the conversation away from theories and back to the actual matters on the docket. Outstanding balances, pending cases, and new citations all come into focus. While the defendant keeps circling back to jurisdiction, the court stays locked on process. That contrast is important. One side is following structured procedure, the other is trying to opt out entirely. In real courtrooms, structure always wins. From here forward, the case moves whether he agrees or not.
A $500 fine with court costs or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
at this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
Ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pre-trial for that entity?
I hear you. And at this point, you are appearing in front of the court. You have put your name on the record. And yes, we are setting a pre-trial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have attached to that case.
And you can provide documentation of such at your pre-trial date, which is going to be June 26th.
So the documentation that I have published, recorded the documentation I have published and recorded on the record, on the state of Michigan record that.
Now we reach the heart of the case, a straightforward driving-related charge. The court carefully explains what's being alleged and what the potential penalties look like. This isn't about philosophy or commerce, it's about operating a vehicle without proper documentation. Instead of acknowledging that framework, the defendant reframes it as personal travel and constitutional theory. This is a classic sovereign pivot. But courts don't debate hypotheticals, they apply statutes. At this stage, understanding the charge matters more than agreeing with it, and that distinction becomes crystal clear.
Says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case. That's I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records.
So,
that good enough?
Whatever documentation you have, bring it with you to your pre-trial date. That is what I am telling you, yes. So, and again, that court date, June 26th? Okay. Will be June 26th at 9 a.m. before Judge Washington. The court will enter that you are standing mute to all charges at this time.
So we're just assuming jurisdiction though, correct?
Yes.
How? From my understanding, that has to be proved before we even proceed with anything else. Am I wrong?
You are not correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before
Here comes the repeated jurisdiction challenge. This is where many sovereign defendants believe they hold leverage, insisting authority must be proven before anything can proceed. In reality, appearing in court and engaging with the process already establishes the court's role. The magistrate keeps things moving, setting dates and explaining next steps while the defendant tries to slow everything down. This exchange perfectly shows how these strategies fail in practice. Courts don't pause operations for ideological debates, they move forward on schedules, filings, and established legal procedure. At this point, the court offers the proper channel: bring paperwork to the pretrial. That's how disputes are handled, not through interruptions, but through evidence presented at the right time. The defendant insists his documents already exist in state records, yet he's still instructed to bring them. This highlights something critical: claims mean nothing without presentation in court. If you believe you have proof, you show it at pretrial. That's the system working exactly as designed, even when someone is actively resisting it.